When you come to our office, there'll be a packet of papers in front of you, and they'll be highlighted with green. The green parts are the parts you care about. So the very first page is the table of contents. It just describes those documents that are in your trust notebook. The primary documents you're concerned about, your trust, your will, the deeds, powers of attorney, those kinds of things. On the very first page, after that, it has the title of the trust, and at the very beginning it says who's in charge. We call them trust creators or grantors. That's you or you and your spouse. And then we also identify who's the money manager of this trust. Those are called trustees. Then in item 1.1, the name of the trust, that's the name that you've elected for the name of your trust. And then the second paragraph that's highlighted in there indicates how the titles on the assets are going to appear. Your deed, your money markets, your brokerage account, those kinds of things. We then move on to Article 3. Article 3 talks about managing the money for you during your lifetime, but it also identifies what happens if you're incompetent and you can't resign. The primary purpose is to avoid going to court for a conservatorship and guardianship proceeding, which most people want to avoid totally because it's so cumbersome and expensive and time-consuming. So what we say is, who's your disability panel? Who are the people you've elected to say can actually declare you incompetent when you don't have the ability to do that? We also have on the following page a reference to a physician can also say that you're incompetent. We're again trying to keep you out of court. We're not expecting these people are going to abuse their powers. We are discussing not only trusts for married people, but single people, so my numbers are going to start to shift here. But the next article is Article 4. If you're a married couple, this says, how does the money get distributed when the first spouse dies? Article 4 for a single person is the same thing as Article 5 for a married couple. And in that article, what it says is the very first thing is 5.1. It says we refer to a list of personal property. Who gets your stuff? Who gets the ring, who gets the rug, who gets the china, who gets the gun, that kind of thing that I'll describe in more detail a little bit later. Also, we have an Exhibit C, which is who takes care of your pets. I'll talk about that also. 5.2 says pay the bills when you're gone. And then the important part is 5.4. Who gets your property? Not the stuff that's on the list, but who gets the bulk of your estate when you're gone as a single person or the both of you are gone as a married couple. And it identifies those individuals. It also discusses what happens if somebody predeceases you. What happens to that person's share? And usually if they're little people that are receiving property, in my world, a little person is somebody under 30. We say the money's managed for them until they're older. That's generally what's in there. Your documents could be different. And the reason we do that is because young people, there are studies that say young people are pretty much idiots until their late 20s. I don't know why anybody bothered to do a study. Sometimes you can just figure that out yourself. But what I'm talking about, once they get to be older, they have figured out how to keep their car payments current, how to not bounce their checks, how to have a regular job, that kind of thing. Then we move on to who's the successor trustee. Who's the successor money manager when you can no longer do that, assuming you were the original trustee? That's Article 8 in a single trust, or Article 9 in married trust. And basically, it usually starts out, it's you, and then if you can't do it, it's you and your spouse. And if you can't do it, then for married people, it's often just the spouse. But then we come to when you, either the single or the married couple, are both deceased or can't do it because you resign or you're incompetent, then it says who takes over. And there's a series of selections that you've made, and that's reflected in that particular article. Then we move on to Section 14.4. This says if somebody fights about it, they don't get a dime. I've done thousands of these by now, and I've never really seen anybody pursue a contest of a trust and be successful. It also says if my law firm gets dragged into it, somebody's paying my fees. I will tell you that happened only once. What happened is I created an estate plan for an older woman. She had 2 children, divided equally between her 2 kids. A month before she died, her daughter went to her mother's home, took her out of the house, took her down the street to a different lawyer, and had her mother sign new documents that gave the daughter a much larger portion of the estate. Then she died, and the son was obviously unhappy about it. The son's lawyer called me up and said, "What are you going to do about it, Susan?" I said, "Nothing. I didn't do those documents." For me to search through my file, it cost $600. So I'm just letting you know if that ever happens, which is rare. That's what Article 14.4 says. Then we get to Exhibit B. That's the list of stuff. That's who gets the china, who gets the rug, etc. And we have this for you to fill out. You need to just date it and sign it. Then you can change it any time you want. That's a nice thing about it. Exhibit C deals with your pets. How do you want to have your pets handled? I'm a dog lady. I've always had dogs. I always will have dogs. And so it's important to me to know who's going to take care of my dog if I can't because I'm too ill to handle it, and I'm recovering from that illness, or the day I'm gone. So that gives you the opportunity to make those kinds of statements. The next document that we cover is the last will and testament. And what this is for is if you've left out any assets from the trust and we need to probate your estate, that's what the will is for. It says probate it, put it in the trust. Hopefully we don't need it, but life is imperfect. I have clients that set up a trust, we put their house in the trust, and then a few years later they sold that house and bought a new house. Never crossed their mind to put it in the name of the trust. So that's what this will is for. When they die and we have a dead person's name on that deed, we need to probate the estate to get their name off of it and get it into the trust. So the purpose of this will is to identify who can do that. We call those people personal representatives. So those are the individuals you've selected. In addition, there's a section later on in the will that talks about drop everything that needs to be probated into the trust. It's called the pour-over clause. The next document is the registration that we file with the court. It just is usually it's a 3-page document that states you are the ones who set it up and who you rely on as backups. Nothing about what you own or who gets it when you're gone. When we file it with the court, there will be a case number assigned to it and a stamp up in the top right-hand corner indicating the time it was recorded. We'll return that to you later. The next document is a financial power of attorney. What this says is who can do modest business on your behalf when you're no longer capable of signing. This is for signing checks and doing things like that. Again, it indicates the people that you've selected in an order of priority. The following document there's a new law in Idaho and a new federal law that relates to your digital assets. So we have this form called Authorization and Consent for Release of Electronically Stored Information. And that just says your agents while you're alive, and if you're not able to effectively represent yourself, you give your agents the power to get at your digital assets. What I'm talking about is your passwords, your emails, your Facebook accounts, those kinds of things. The next document includes 2 things. These are your health documents, a living will and a health power of attorney. And our legislature has combined them into one document. So even though these are 2 separate documents, there's only one place to sign at the end. The first one is a living will. And this is a document that says if a doctor certifies that you have a terminal illness and that your death is imminent, which means you're knocking at death's door, or you're in a persistent vegetative state, you get all the pain pills you want. And on the second page of that, you get 3 choices. The first choice says find every fancy machine out there or procedure and do that as long as possible. The second choice is no, don't bother with that, but do give me nutrition and hydration with tubes. I'm talking nose tubes, stomach tubes, out with tubes. And then the third one says, don't even bother with that. Just keep me comfortable and let me go. It doesn't matter to me which one you choose, but you need to make one election. Most people choose the last one. I've had very few people choose the first one, which says use everything in science to keep me going. And then some people choose the nutrition and hydration or an alternative of the 2. When you see your documents, you'll see that I've had written on them summary explanations of what those 3 choices are. Because sometimes when you read through them, you just get lost in the weeds and people make the wrong election. The next page on those health documents is Article 4, and that talks about a physician's order for scope of treatment. It's called a post form. And some of you may have it and maybe not. And so you just need to indicate if you have one of those forms. If you do, great. If you don't, and you do one later, this document still covers that. By the way, we will make an extra copy of these health documents for your physician, so you can give it to your physician at your convenience. And in addition, we will put in a sample form of the post form if you ever want to discuss that with them. We glide right into the health power of attorney. Again, there's no place to sign the living will by itself. And in the health power of attorney, what you do is you designate who you want to be your agent. Who's going to talk to the doctor on your behalf when you can't communicate effectively? You get to choose on this document whether you want to donate your organs or not. So you can say yes or you can say no. And then there's also a section to indicate who do you want to have make the choice for where you're going to go if, heaven forbid, you need to end up in a facility. You broke your leg and you need to go into a rehabilitative facility for a while, or you need to end up in assisted living or a nursing home facility. Who do you want to have make those choices as opposed to a total stranger doing that? And the way these forms are set up, on the last page, there are alternates to the first person you indicate as your health agent, the one to talk to the doctor on your behalf. The last document in this pile of papers is Exhibit A to the health documents. And this exhibit allows you to decide to let the health professional know what you want to have as restrictions on these health documents. I have clients who are allergic to Tylenol. They're allergic to sulfur drugs, penicillin. I myself am allergic to paper tape and adhesive tape. It's like you give me poison ivy when that goes on. I have clients who don't want blood products or have other religious preferences about their healthcare needs and care. So if you want to qualify these health documents, that's where you do it on Exhibit A, and then that gets attached to the health documents and given to your agents.